I'm getting a lot of questions about the borrower defense to repayment program, and understandably why. Right now, we have a huge settlement that has been going on since 2019, which is the Sweet versus McMahon settlement. And we have student loan borrowers who are now finally starting to see their student loans discharged after years of waiting. But what's important to know, if you are a borrower, you have federal student loans, and you are putting in a borrower defense application, or you have already submitted your borrower defense application, and you submitted that application after November 15, 2022, that means you are not a part of the Sweet versus McMahon settlement. And what that means for you is that even if you put your borrower defense application in and your school was one of the schools that was on that long list of schools that is mentioned in the settlement or that is a part of the settlement, there's no automatic relief that is tied to that for you. There's nothing underneath that settlement that would include you to have your loans discharged. So what that means for you is that you have to know what the rules are of the borrower defense program and what that means for your application and how your application is going to be evaluated. One of the first things that you want to do is look at the application. You can view the application. It's a free application on the Student Aid website. So when you go to studentaid.gov, click loan forgiveness, and that's where you will see borrower defense to repayment. Now, there's a lot of different things that is happening with the borrower defense program. And again, when we talk about the Sweet versus McMahon settlement, anything that went on with that settlement, it would have nothing to do with you as a applicant after that November 15, 2022 date. And what that means is when you read the instruction of the application, it tells you that your application may be evaluated over multiple regulations depending on when your loans were dispersed or when your loans were consolidated. Meaning there's different requirements that can come for you. There's different claims that you could bring against the institution. All different type of things can take place when that application is being evaluated. We also have with the passing of the One Big Beautiful Bill Act and what that did to the borrower defense program. There's a 2022 regulation, and this was during the Biden administration that was introduced, meaning that it would have been a lot easier for borrowers to have their student loans discharged under borrower defense. I mean, there was more protections with the 2022 regulation. But with the passing of the One Big Beautiful Bill Act, that rule cannot be implemented for loans that were dispersed prior to 2035. Then we also have the 2027 appropriations bill, where there's even more mention about the borrower defense program, where Congress doesn't even want to fund any type of money to implement borrower defense under those regulations. So it's just a lot. There's a lot of different things that's going on with the borrower defense program. But that doesn't mean that you don't submit a claim against your institution if you have one. If you believe that the borrower defense program is that avenue for you to get your student loans discharged because there was some type of misconduct or misrepresentation that took place when you borrow federal student loans to attend an institution, then you absolutely want to submit the claim. But one thing that we don't want to do is to be submitting a claim falsely. If you don't have a claim under borrower defense, that is not the avenue to get your student loans discharged, because you are submitting a claim under penalty of perjury. And I understand when we're talking about the Department of Education and all of the janky shit they have done, I get it. You want to go after these institutions or even just the Department of Education with your frustration with the Department of Education. But what we don't want to do is in all of this become exactly like what we're fighting up against, which is this corrupt ass student loan system. So when you're submitting your borrower defense application, just make sure that you're reading the application, reading the instructions of the application, because it'll tell you exactly what you need to know. Also, it gives you the information about the regulations as well. You can go read the regulations to understand what exactly is harm. What does the Department of Education constitute as harm? What is financial harm? I know sometimes, a lot of times, we can get emotionally connected to all of this. And I know 100% it is a lot to deal with. But one of the things under borrower defense, your aggravation, your emotional distress, your pain and suffering, that is not a basis for a discharge under borrower defense. So you have to know what the Department of Education is talking about when they are talking about being financially harmed or harm in general. So again, the application is on the Student Aid website. Make sure that you read the instructions so that way you'll know, how to structure your claim, what things will give you that rise to it to be able to bring a claim against an institution. And then also, what happens after you submit it. I hope that helps. And we're going to get through this. I know it's a lot, but we just want to just have an understanding of things going forward. So that way we're not submitting anything just blindly. There's no reason to. All the information is there. We just have to go out here and utilize the information that is available to us. One of the things that they know that majority of people aren't going to do is read. But we're in a place right now where we have to go see what the laws state. We have to go see what these regulations state and how to be able to use this information to protect ourselves. All right. Good luck, y'all.